The next case to come before us this morning is Gustafson-Jowiski versus Leslie Gustafson-Jowiski, excuse me. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, please let me know when you get started. I'm keeping track of the clock. Please don't use the names of any victims or minors. I don't think it's relevant to this case, but we are recording these oral arguments and it will be posted on the court's YouTube channel. We read the briefs. We're ready to proceed when you are.
Thank you.
Would you like to reserve any time for rebuttal?
Yes, please, if I may reserve, I don't think I'll need it 5 minutes.
Okay, thank you. And we need to use this podium up here.
All right.
Thank you.
Thank you. Good morning. May it please the court, my name is Attorney David Berta, and I represent the appellant in this case, Leslie Gustafson-Jowiski. As the court is aware, this is a case that came back on a remand. A lot of those issues have been disposed of, so I won't reiterate those. They're not necessary for this case. This case ultimately, Your Honors, is a very simple matter in the sense of the issue presented. There is just one single issue. The parties, in fact, were entered into a separation agreement at some point and were legally separated in 1996. They were formally divorced on April 16th, 1997. Sometime thereafter, actually about 20 years thereafter, the plaintiff in this matter, the appellee, I should say, Daniel Jowiski, went back to court asking that the QDRO be amended or changed. The original QDRO was, in fact, processed by the court. It was made into law and distributed to the parties. The issue came back as to whether or not Mr. Jowiski's money that he put into this retirement plan is, in fact, part of the appellant's money as well. We did have a hearing on this matter, Your Honor, which the court has the transcripts to, and I have alluded to those. Indicated the QDRO group, which was in fact a witness on behalf of Mr. Jowiski, certified and determined to be experts in the field. They had indicated that in fact the original QDRO did meet the requirements of the intended divorce. So in other words, it was done correctly. It did divide the pension.
But did they meet the requirements?
I think they did.
Of the intent of the divorce decree?
Your Honor, I think they did, and I'll tell you why. Because I think in order to modify a property distribution as indicated in my brief, both parties have to consent, and I don't think both parties in this matter consented. I do understand that...
Didn't they consent by agreeing to that provision within the divorce decree?
I disagree, and I'll tell you why. Because I think it was foreseeable as to what he was doing. So in essence, if you divide property up, and then you start putting additional funds into something that's already been divided, common sense would tell you that that would increase. And he did testify that he knew that that was increasing, but he waited 20 years to go back to court to actually change that provision. He could have easily just had another 401k started perhaps with the company, an IRA, some other additional things of that nature. I'm not going to pull the wool over anyone's eyes. I think I've said it numerous times. As far as an equitable argument, I would agree. This is kind of not fair in that sense. But I think the court and the law is full of inequitable arguments. Like we have a lot of deadlines, a lot of things of that nature, and once they're gone, they're gone. And in this situation, the QDRO, as per the expert opinion, and as per Mr. Jowiski himself, he testified, which I have alluded to, it did meet the requirements and the criteria that they originally agreed upon. He actually changed...
In essence, it matched the language of the decree.
I'm sorry?
In essence, it matched the language of the decree, the decree in 1997.
It matched the language of the decree in 1997. It was a division of property. A division of property cannot be revisited by the court as per the law unless both parties agree or there's a provision to revisit it.
Did the court retain jurisdiction in this case?
They retained jurisdiction to, and I believe it specifically mentioned to order the QDRO into effect or to effectuate its provisions, something of that nature.
But doesn't the court always have jurisdiction to enforce its own order and also aid in execution of the original order?
It has jurisdiction to do so if it's retained jurisdiction. So for instance, in a spousal support case, if the court doesn't retain jurisdiction, it cannot revisit it.
It can't modify, correct? Or
It
can it
cannot
enforce
modify.
the original order?
Correct. It cannot modify it if it's not retained. Correct.
Is there a distinction between enforcing its original order and modification?
That's a great question, because I think that's part of it, and I think that, that is my argument here. It's not really a modification. This is actually, in essence, an argument to go back and actually, pursuant to Civil Rule 60B, to actually correct a provision. So that would be our argument. That's why I think that the provision of the case in Walsh, which I have cited, is
So
effective.
correct or clarification?
I don't think they're clarifying at all, because you have to understand, some facts took place after the divorce. He put money into a retirement plan that was already been divided. And it said 50% of that retirement plan, and that's how Ford Motor Company interpreted it and divided it 50%. They said that's what the provision was, and Ford wouldn't correct it otherwise, the record states, unless they went back to court and changed it. Then they would follow whatever the court ordered. So certainly I do understand that line of reasoning, and I would not be amiss to say that if I was sitting in your position or a judge in domestic relations, as I once was, thinking, because there's an equity argument, there's a legal argument here, what should it fall upon? I think for the sake of jurisprudence, it has to fall upon my client's way. Not so much as that she gains something from it, but there has to be conclusions in cases. 20 years later, he had the foreknowledge to know that if he puts additional funds into a retirement plan that's already been divided, it's going to increase her value. I think that's why the 60B takes place. So the real ultimate question in this case is, does the court have jurisdiction to go back and correct it? I think they're correcting it. I don't think they're interpreting it. I think they are modifying it by issuing a completely new QDRO. That's a modification. If they're clarifying it, I don't think they would have needed a new QDRO. But they put a completely new QDRO, which changed the original conditions of the divorce and how the property was split. And I would reserve any time for close. Thank you.
Thank you. You'll have your full 5 minutes for rebuttal.
Thank you very much.
May it please the court, Giovanna Premke on behalf of Mr. Jowiski this morning. Again, we're here on one assignment of error that the appellant is arguing that the court lacked jurisdiction because the parties did not consent to the modification. There is, I'm not going to get into the facts too much. I know this court has already had a decision, a prior decision, but I do want to clarify that what opposing counsel said, that this issue was discovered. It wasn't discovered until December 2019 when my client decided to retire from Ford. And that's the first time that itemization was asked for and the miscalculation was discovered. That led to the filing of the motion in this case, which is why we're here. The decision by the magistrate and also the judge are really well written, and we would ask that you affirm those decisions. I'll go through, the magistrate's decision specifically points out some law that I also cite in my brief, but I'll go through line by line here. First, he cites Supervised Code 3105.1713AI, and that defines marital property as during the marriage. That acknowledges that but the court also acknowledges that under I, it says that any future modifications would have to be consented to. I would agree with Judge Flagg-Lanzinger that they agreed to the modification in the original decree. And I would actually disagree that the decree is correct. It's the modification, or it's the QDRO that they're trying to modify. And the law, specifically, the magistrate and myself,
How do they want to modify it, the QDRO specifically? What do they want it to say other than what it said before?
Well, I think that the decree specifically says that it's while, the number of years while married. And I cite that in my brief as well, page 5 of my brief, but also page 8 and 9 of the decree. And the way the QDRO was done, apparently, or the way that Ford interpreted the QDRO, that it was total number of years of contribution to the plan.
Well, there's two parts of it. Did the language of the original QDRO, did it somehow change what was said in the decree?
Yes, I would say it's different. It's they're different. Again, the
How are they
way
different?
Well, they're.
I'm sorry, you're saying they're different. I've reviewed them briefly, look like with the same length of the decree, so I'd like to know how you're telling me they're different. I understand your client doesn't like the result that he's getting because the result, he says, is not what he intended from this. But how is the decree language different than from the decree language? Where they say we have the numerator, that's the amount of years they're married, we'll have the denominator, that's the amount of time you worked before.
Right.
And we'll look at that and divide based on who gets their pension. How is he saying this Kudrow language is different than what the decree was?
Well, again, I think that the way that Ford's interpreting this Kudrow is that it's outside of the years of marriage. So I would say the intent of the decree, and if you look at the language specifically in the decree, it allows for modification of the Kudrow to go with the intent of the parties. It's clear what the intent of the parties was, and in fact.
Was there testimony from both parties at some point on what their intent was?
I can't say specifically yes or no, but there is a case in which the, that cited, I think it's Coit versus Coit, that anything, based on the outside of the number of years of marriage divides non-marital property. And the decree can't divide non-marital property that's not subject to jurisdiction of the court to begin with. So there's an argument here, and again, in this Hoyt case, that that's dividing a non-marital asset that, that you can't do. I think that.
Well, they have to in this case. There's going at some point, this person is going to retire. He's going to have an asset that's partially marital and partially non-marital. And they're trying to divide the marital portion only by doing the qualified constellation.
Correct.
That's all they're attempting to do.
Correct.
So they're not trying to touch that other money.
That's the way that Ford's interpreting it, to touch the other money that he's contributed after the marriage.
Well, how did they interpret it?
They interpreted it that it would divide all of his years of contribution. So that would, it's a significant difference. I know that there's been an equity argument that my opposing counsel here doesn't disagree, but it's the difference between, I have the exact numbers here, but.
Domestic courts, aren't they courts of equity?
Yes, and it's the difference between 1,689 per month under the way that Ford's interpreting it now, and that's the total years of contribution. I mean, recall that they were divorced in 1997, and that it wasn't until 2019 that he went to go get divorced, and he's contributing during this time. And what the trial court decided was that it should be $287.08 per month. That's a significant equitable difference.
As I understood, his problem is I started contributing a whole lot more after I retired. Therefore, it's unjust now because I started doing it after. Regardless of whatever system we're going to have, they're going to say they're trying to divide that marital portion based on the years we're talking about.
No, I mean, and I think the intent of the parties is clear because as my opposing counsel say, why wouldn't he, why would you ever contribute to an account that you thought was also going to your ex-wife when you could open a new
Are we
account?
limited to figuring out the intent of the parties from the language of the separation agreement? They made an agreement, in this case, they had their decree, this is what their intent was, they expressed it. What else are you looking at to tell me what their intent is other than the decree?
Again, I believe it's number one, equitable, number two, their actions. So his actions in continuing to contribute and to contribute more, again, wouldn't be a logical conclusion, wouldn't be what a logical person would do. So I think that, and I think it's also clear from the law, you can't divide a non-marital asset. So again, I think that's something also to consider.
Is it your view that the court modified the order in this case? The initial decree?
No, I think that there, and again, the law that I cite, that Sullivan versus Ramsey, Kudrow is only an aid in execution of the decree. And what I believe that the court had done is they clarified the Kudrow, which is just an aid in execution of their decree.
Do we have a proposed new Kudrow yet, or is it something that's going to be submitted to the court in the future?
I don't believe they have gotten that far because of this litigation that's been ongoing. I do also want to acknowledge that opposing counsel repeatedly cites Walsh. Walsh is significantly different and ironically cited because in Walsh, in military pensions, you need 10 years of service in order to divide your pension that way. In that case, they only had, not 10 years of service, 10 years of marriage could also be service. 6 years of, they only had 6 years of marriage, they didn't have 10. So the court impermissibly changed the number of years of marriage. And that's basically what they're arguing here, is to extend the marriage beyond to 2019 or whenever, the contributions stop, from 1997 to 2019. And in that case, the Ohio Supreme Court did say that you can't impermissibly change that property division without consent. But in that case, it wasn't a matter of interpretation of that decree or the Cujo is.
Did the Court of Appeals and the trial court say, we're doing this based on what we think the intent of the party was, and we want to change things based on the intent? The Supreme Court said, you can't do that, you have to look at the language of this decree. You can't just say what the intent is.
I think Walsh is significantly different. They changed the number of years of marriage here in Walsh, and in this case, it's significantly different. They're not changing, it's an interpretation of what the decree stated. And I don't think that the decree as it's written cannot be interpreted as it's during the years of marriage. It's pretty clear. It says while married. So again, also Pearl versus Pearl, that's a case that indicates that Cujo is subject to review for errors of law. And that a Cujo that enlarges the division of property impermissibly modifies the decree. And again, that would, be the argument here in this case, is that it impermissibly enlarged the number of years of marriage here, which again, is ironic because that's basically what the Supreme Court said in Walsh that you can't do. You can't, divide that non-marital property, you can't enlarge the years of marriage.
Well,
That's
this
exactly.
does this quadro submitted enlarge the years of marriage in some capacity?
Yes, it's basically enlarging it until the end of his contribution period here in 2019. Because the way that they're saying is that it has to be divided by the number of years, instead of the number of years of marriage, the number of years of contribution, which is after the marriage, dividing non-marital assets.
That's exactly what the original decree said.
No, I would disagree with you on that. I don't believe that that's the way that language is read.
So
It
from the
specifically says while
testimony
married.
at the trial court, was the quadro expert saying they're trying to divide 14 years of marriage? As I recall, they're married for 14 years.
About 8, they were married in 82 and divorced in 97.
Roughly 14, 15. Are they trying to divide some other length of time for the length of the marriage in the quadro testimony, the expert?
Well, they're trying to divide by his total number of years of contribution up until 2019, so that's what I'm saying, in a way, it enlarges this marriage, or at least for purposes of that property. So again, I would ask that you affirm the court's decision, and the ruling that the property division should be the $287.08 per month. Thank you.
Thank you, counsel. You have the full 5 minutes of
Thank
rebuttal.
Thank you. I think, and I'll bring this up at the conclusion here, the crux is, and it's the bottom of page 6 of my brief, the transcript provided Ford did properly approve the Cujo that was drafted in 97. The answer from the expert, Mr. Myers at Cujo Group, was, that is how, this is his answer, that is how the original Cujo was drafted. The original Cujo was drafted to make the coverture and multiply it by the final benefits that came out of that plan. It did not distinguish between contributory and non-contributory. So the plan did implement the Cujo as drafted, that's what he said. Question, so the plan in your opinion was correct? At least Ford's analysis is correct when you look through the original Cujo as it is today. He said yes. And then question, your analysis is based upon what would have modified a Cujo that separated his contributions from non-contributions that he did make strictly through Ford. He put, that may have been, and he says, well, yeah, I believe you're saying that my analysis would be, if we drafted, we would need to draft an amended qualified domestic relations order to effect. So it's contributory versus non-contributory. There's nothing in the original decree that indicates whether it's contributory or non-contributory. It still was divided into the years of marriage. He just put more money in there, so that made her share greater, because his contribution even though it came after, makes her share of those years greater, because there's no way for them to break down what amount made that greater, unless they use contributory and non-contributory, which makes no mention of whatsoever in the original divorce decree. So I believe that the Q-Drill was drafted correctly. Everyone testified it was. There's no testimony that says that they did not have a meeting of the minds. My client, Ms. Jowiski, did not actually even appear. She's out of state, as I'm sure you're aware, reading prior transcripts. She did not testify, therefore it was only testimony of him, and Mr. Jowiski, Gustafson-Jowiski in this matter, said that it was originally drafted the correct way, but he chose to make different contributions as the time went on, which was actually not credited to the old one, but it made that amount go up over investment time. So that was his mistake. However, I believe that the original decree and the original Q-Drill was correct. This is in fact modification of a property interest. It's not interpreting it and making it effectuated. It's a complete modification. If it wasn't a modification, why would the need be to draft a completely new Q-Drill? So with that, I believe that the magistrate's opinion as adopted by the court is incorrect.
Do you think the decree gave them the authority to modify the trial court chooses?
Gave them the authority?
Yes.
The original?
The
No.
original-
No. I believe to effectuate the terms and the intentions of the party, which we can only have his intention and her intention. She didn't testify. He did testify and said the original Q-Drill was correct. However, he contributed after the fact, which obviously he could have known that could happen. That was not part of the original record because he wasn't contributing at that time. I believe he indicated what had happened is Ford was offering some kind of increase. If you contribute, you get more money, get out sooner, which auto companies have done and have done so back then. Probably should have consulted with a tax accountant, an investment broker, and the lawyer. But I think he's stuck with what it is. I do admit, obviously, in the court of equity, strictly equity, you may say, well, it's not fair. But sometimes things are not fair. But it is fair if you really think about why he did it. He shouldn't have done it that way. And it is division, in my opinion, of property, which is not permissible unless it's reserved jurisdiction specifically to redivide that property, and it hasn't been done so. Only provision in that decree was to effectuate the purpose of this agreement. Everybody testified it does in fact divide those years of marriage. Even their own experts said that. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision in due course, which will be mailed to all parties to this appeal by the clerk of courts, as well as posted on the House Supreme Court website. Thank you.
Thank you very much. Have a good day.